Hi everyone. Thank you for joining us today for the CUNY Selected Issues on Citizenship and Immigration Law, Family-Based Immigration. We can have the next slide. I'm going to turn it over to Kelly, who's going to give some technical information.
Hi everyone. We'll be taking Q&A at the end of the session from our two panelists, and if you would like to submit questions, please submit them in the chat boxes, and you'll see that there are pictures of where the boxes are and what they look like. If you experience technical difficulties at any time, please call 1-800-263-6317, press 1 for GoToWebinar, and then 2 for tech support. All right? Thanks. So, Patricia, go ahead.
Thank you. Next slide. So my name is Patricia Wonder, and I'm an instructor at CUNY School of Professional Studies. I'm also a partner of my own law firm. We have the next slide. We're delighted to have two presenters today, Barbara Brandis, who's the Senior Managing Attorney of Barbara Brandis and Associates, and Adam Cohen, who has his own practice. Can we have the next slide? We'd like to thank our sponsors, CUNY Citizenship Now and CUNY School of Professional Studies. Next slide, please. CUNY School of Professional Studies offers an Immigration Law Studies Advanced Graduate Certificate Program, which has courses such as Intro to Immigration Law, which I'm actually teaching this summer online, Business Immigration Law, Family-Based Immigration Law, Proceedings in Immigration Court, and Naturalization and Citizenship. Next slide, please. If you'd like more information on the School of Professional Studies, you're more than welcome to go to the website, which is www.sps.cuny.edu, and you can find information about the Immigration Law Program. Next slide, please. CUNY Citizenship Now is the other sponsor of today's webinar. The goal of Citizenship Now is to help individuals prepare their N-400 applications for naturalization. Can you go to the next slide? Citizenship Now has immigration centers all over New York, and there's a map there with information on the different centers. The centers offer free immigration services to all members of the community, CUNY students and also non-students. Next slide, please. CUNY Citizenship Now has a volunteer corps of people who provide free naturalization application assistance at Citizenship Now events in New York City that usually take place on Saturdays. You go to the next slide. If you'd like more information about Citizenship Now, or if you'd like to volunteer, you don't need immigration experience to volunteer. You're more than welcome to complete a registration form at the website that's on this slide. It's cuny.edu, Citizenship Now, volunteer. Next slide. We're going to turn it over to our substantive portion now, our two speakers, and they'll be discussing family-based immigration.
Next slide, please. Qualifying for family-based immigration. In this webinar, we'll be talking about some basics of qualifying for family-based immigration, as well as some distinctions. How can family members sponsor each other for permanent residence? There are specific family preference categories under which a lawful permanent resident, which we'll abbreviate as LPR during this presentation, or a U.S. citizen can sponsor a child, parent, spouse, sibling, or son and daughter over the age of 21. Now we'll be getting into some definitions and some technicalities that you should be aware of. Next slide, please.
The definition of child under the INA forms the basis for most family relationships except a spouse. The definition of child can be defined under INA 101B1, and a child is either one who is born in wedlock, where the parents are married, a stepchild under 18 when the step relationship was created. That's when a child's parent marries a person who can illegitimate child legitimated before 18 years of age, a child born out of wedlock, and a child born out of wedlock, either a mother or father can sponsor them, but the father must show a relationship before the 21st birthday. And the last category is an adoption. If a child is adopted, and there's two types of adoption. Adoption of orphans, where both parents are not in the picture, whether by death or abandonment, or on straight adoption that occurs before the child's age of 16, and in that way the parents must have 2 years of legal custody and 2 years of the child residing with them before immigration can approve the petition. The next slide. There are a number of ways to legitimate an illegitimate child. The first way is by marriage of the natural parents. Let's say you have two children that were born when the parents weren't married, and then the parents can subsequently marry, and that would legitimate an otherwise illegitimate child. By a judicial decree, which is a court decree. By a formal declaration of paternity. Also by an acknowledgement of paternity. And one thing that's very important is there are many countries that have abolished the distinction between legitimate and illegitimate children, and in those cases all the children are considered legitimate whether or not their parents have married. Next slide, please. And then a little bit more about adoption. We talked about already about the child must be adopted before they're 16 years of age, and they have to be, if they're residing with their parents, the primary control of the adopted child has to be with the adopted parents. Sometimes you have children who are still residing with their natural parents, but for some reason they can't take care of them. You have to show that the adopted parents have primary control over those children. And once adopted, the natural parents cannot get immigration benefits once the adopted child gets United States status. Also, there are special rules for orphans. You can be orphaned by the death of a parent, disappearance, abandonment, desertion, separation, or loss of both parents. And there's very specific definitions for both of those things under the immigration nationality law and especially under the regulations. And they read it as the loss has to be by both parents. The separation has to be by both parents. If one parent is alive, then they must show they're incapable of providing proper care, and they have to irrevocably, in writing, release the child. And one other thing I want to mention is that if two siblings are adopted, only one needs to be under the age of 16 and the other can be under the age of 18. Next slide, please.
The definition for parents is found in the Immigration and Nationality Act, Section 101B2. But as we'll see, Section 101B2 refers you right back to the definition of child in 101B1. A parent, father or mother, is established by that definition of child. So to decide whether someone is the parent under immigration law, USCIS in the Immigration Nationality Act looks to the definition of child in Section 101B1. So if you establish the relationship of child per the definitions, you've established a parent relationship exists as well. For sponsoring parents, only U.S. citizens 21 years or older may petition for those parents. It's also important to note that stepchildren can petition for parents as long as the step relationship was formed before the child's 18th birthday, and that step-parent-stepchild relationship can continue even after divorce. Next slide, please. For siblings to sponsor each other, they must meet the definition of child of at least one common parent. So each sibling must independently meet the definition of child from one mother or father that the two siblings share. It's also important to note that permanent residents cannot sponsor siblings. Only U.S. citizens can sponsor their siblings. A U.S. citizen may petition for natural and step-parents, just as they may for stepchildren or step-siblings. Next slide, please.
Now we have a poll question, but just before we discuss the poll question, I just wanted to add some things. If you sponsor somebody, sometimes the children's names are not on the birth certificates, or let's say the parents' names are listed as a pet name. There is ways to establish relationships by other than the primary documents, and that you can do it by secondary evidence, by school certificates, by baptismal certificates, by DNA, they're using that a lot, and also by affidavits. And with that, we have a poll question, and it's Tina, who has 3 children, who married Jeff, who's a U.S. citizen. Jeff married Tina in 2006 when her son Lawrence was 22, the son Robert was 17, and the daughter Susie was 12. Everybody was born in Jamaica, and they're all Jamaican nationals. And the poll question is, can Jeff sponsor all 3 of Tina's children? Think about it for a minute, and we're going to go over the possible answers, and then we'll discuss it. So you have to remember while you're thinking of that Lawrence was 22 when they were born, when she was married, Robert was 17, and Susie was 12. Now the first answer, I'll read all the different answers. I'll give you a chance to think of which one you think is right, and then we'll discuss them. A, he cannot sponsor any of them because he's not their father. The second one, Jeff can sponsor all 3 children because they're his stepchildren. The third one, he cannot sponsor Lawrence because Lawrence was 18 when Tina and Jeff married. And the fourth question is, he has to sponsor Tina and she can sponsor the children. I'm going to give you a minute to think about it, and we'll talk about each one. Okay, well, the majority of the persons answered, and you picked question 3. He can't sponsor Lawrence because he was 18 upon their marriage, and that is the correct answer. And I'll go over the other 3 potential answers and explain why they weren't correct. Well, the first answer says that Lawrence cannot sponsor any of them because he's not their father. But that's incorrect because Lawrence is the step-parent by immigration law of Robert and Susie because the marriage occurred before they were 18. He cannot sponsor, B is wrong because he cannot sponsor all 3 because we just discussed that only 2 of them are his stepchildren. And the last answer is incorrect. Although Tina can sponsor all 3, Lawrence can also sponsor Robert and Susie before, and so therefore Tina doesn't have to wait till she gets her residence. Lawrence can simultaneously sponsor Robert, Susie, and Tina. And next slide. Okay, and now we're going to talk a little bit about preference categories because there are different categories for sponsoring a family member. And family preference petitions include petitions for immediate relatives of U.S. citizens and those for certain other relatives of U.S. citizens and lawful permanent residents. That is that immigration breaks it down to persons considered immediate relatives and persons that come under the preference categories. USCIS, next slide please. USCIS considers some family members to be immediate relatives, and that means that they're outside the quota. And immediate relatives, which means that visas are immediately available for these categories. And immediate relatives include parents, spouse, and unmarried children under 21 years of age of U.S. citizens. And that also includes stepchildren, all the other definitions of children that we previously discussed, as long as they were under 21. And immediate relative petitions, as I said, are not part of the overall cap on immigration, and they're not subject to the preference quota categories, meaning that they're immediately available. The one caveat is that beneficiaries of immediate relative petitions cannot add derivative beneficiaries to their application, which means, here we go back to Jeff again. Jeff needs to have a sponsor. Although he can sponsor Tina and the children, he cannot do it on one I-130 petition. He must file separate petitions, one for Tina and one each for the two children that are capable of being sponsored.
Next slide, please. When we're not talking about immediate family members, other family members fall under family preference categories, where there's a preference system and there's a fixed number of allocated immigrant visas available. So there is such a thing as a preference system where, through a calculation, they are able to determine what number of immigrant visas are available at any given time for family-based I-130 petitions. Those are based on certain preference categories, which include the following. There is F1, which means family-based preference category 1, for unmarried sons and daughters of U.S. citizens. Now, sons and daughters there refer to those over 21. Family-based 2A includes spouses and unmarried children under 21 of lawful permanent residents. Family-based 2B refers to unmarried sons and daughters, again over 21, of lawful permanent residents. The third family-based preference category, F3, are married sons and daughters of U.S. citizens. And finally, the fourth family preference-based category are brothers and sisters of U.S. citizens, remembering back that permanent residents cannot sponsor a brother or sister, only U.S. citizens. Immigrant visa availability for preference categories is restricted annually to 480,000 visas overall, less the immediate relative visas. And there's a floor of 226,000 visas, so no matter how many immediate relative visas there are, it cannot reduce the number for the rest of the preference categories to under 226,000 visas. With preference categories, derivative beneficiaries are allowed. So referring back to the poll question, where because it was an immediate relative petition, there had to be separate I-130s filed for the stepchildren, where somebody under a preference category has a derivative, there can be just the one I-130 for the primary beneficiary. Next slide, please. Priority dates. A priority date refers to the date the family-based preference petition was filed. So if you're filing an I-130, the date that that petition was filed will become a priority date, and that's going to determine the order in which a visa becomes available. And that's why priority dates are so crucial. Priority dates of available visas are updated monthly in the Visa Bulletin, which is published by the Department of State. Next slide, please.
We can go back one, please. The Visa Bulletin? Yes. So the monthly Visa Bulletin, which comes out from the Department of State, and that is available on the website www.travel.state.gov for the monthly visa listing, lists the cutoff dates for each preference category in the area of chargeability. A beneficiary's priority date must be on or earlier than the cutoff date in order for an immigrant visa to be available to the beneficiary.
The current Visa Bulletin for May 2011 is contained in this slide, and as you can see, it's broken down. On the left side, you see family sponsored, and you see the category 1, 2A, 2B, 3, and 4. Those are the preference categories. And in the next column, we have all chargeability areas except those listed. And the dates that you see are the priority dates. Those are called the cutoff dates. So the priority date for someone, for example, in the family-based first preference to be able to file for permanent residence in May 2011 would have had to have a priority date earlier than May 1st, on or earlier than May 1st, 2004. And that's for all countries with the exception of China, mainland-born, India, Mexico, and the Philippines, which, due to what they call oversubscription, may have an earlier or different date. So you have to make sure you know which country is being charged and then look to see if there's a separate distinction on the Visa Bulletin. As we mentioned, the Visa Bulletin is released monthly by the Department of State, usually about 2 weeks in advance of the month. So this bulletin was released in the second week of April at the website indicated on the bottom of the page. Next slide, please. Now we turn to another poll question. We have Melinda, who is a 34-year-old unmarried national of the Philippines, where she still lives. Her father, Tomas, a lawful permanent resident, filed an I-130 petition for her on May 21st, 2000, which was approved. Is Melinda's priority date current? I'll give you a minute to think about that and make your choice. And while you're thinking, let's talk about certain distinctions and certain parts of that question we have to pay attention to. We have to know what the person's priority date is. We have to know what family-based preference category the person falls into. And we have to know the country of chargeability and see if there's any distinction on the Visa Bulletin. So our choices here are no, because Melinda is a national of the Philippines. Yes, because she is in the family-based 2B category. We're not sure what her priority date is, so we can't determine. Or none of the above. Now let's see what the results are. All right, there was a fairly big split on this, which is good. The first question, no, because Melinda is a national of the Philippines, is correct. And 22% of you chose that. Let's talk about how we come to that answer. Because Melinda is over 21 and is the unmarried daughter of a permanent resident, she falls into the family-based 2B, unmarried sons and daughters of LPRs category. So we know that she's in that preference category. We also know that she's a national of the Philippines. So on our Visa Bulletin, if we look to nationals of the Philippines and find the cutoff date for May 2011, that date is March 1st, 2000. Well, Melinda's priority date in this case, which is when her I-130 was filed, was May 21st, 2000. So she's just shy by about 11 weeks. She misses the cutoff date by about 11 weeks, but hopefully within the next few months, her date will be current. Looking at the second choice, yes, because she is in the F2B category. Well, she is in the F2B category, and it's otherwise current for other areas, but not for the Philippines. Not sure what her priority date is. We do know that because we know when her I-130 was filed. An interesting note here, we'll get to upgrading petitions, and we'll talk about that in further detail, but if you notice on the Visa Bulletin, if she were the unmarried son or daughter of a U.S. citizen, which is the first preference category, the cutoff date is July 15th, 1995. So almost 5 years further back than her cutoff date for being the unmarried daughter of a permanent resident. So for her sake, she'd better hope that her sponsor does not gain citizenship until she can be adjudicated.
I just want to add to that if I can right now, because part of the Child Status Protection Act was that they can elect to remain under that other category. So for the Philippines, when it's oversubscribed and the benefit is, let's say, the child of a resident rather than the child of a citizen, they can choose to remain a child of a resident and ask not for their category to be converted.
Right. However, in this case, she was over 21 when the I-130 was filed for her, so the Child Status Protection Act is not going to apply for her, but we'll talk about that in a little more detail when we get to Child Status Protection Act. Next slide, please. Okay, chargeability and cross-charging. Where we have derivative beneficiaries, this is a very important topic to know about. Foreign state chargeability refers to a country's quota to which a beneficiary's immigrant visa gets charged. So if someone is a national of Germany, then Germany and their quota is going to be charged. And if someone's a national of the Philippines is going to get charged. Only 7% of the total available family-based immigrant visas are available to each country. So that's what can cause oversubscription if you get over that threshold. Chargeability is based on the beneficiary's country of birth. Even though they may be a citizen of another country, we have to look back at the country of birth. Cross-chargeability can be particularly helpful where the immigrant visa is unavailable for the primary beneficiary. The country of birth of a derivative beneficiary may be charged instead. So, for example, I have represented the married son or daughter of a U.S. citizen who is over 21, is from Mexico, is married and has 3 children. And her spouse and 3 children were going to apply for permanent residence as derivative beneficiaries. However, the cutoff date for that category as of May 2011 is November 15th, 1992, and her application was filed closer to 2000. So she would have had quite a long wait. It turned out that even though she and all of her children were born in Mexico, her husband was born in Colombia. So we were not only able to charge his visa to Colombia, but we could use his nationality for all the applicants, for the primary beneficiary and the 3 children. So rather than waiting for the cutoff date for Mexico to become current, they were able to be charged under his nationality. Next slide, please. Conversion of preference petitions. This is something that happens when the beneficiary's qualifications for a preference category change. That beneficiary's petition can then convert to a new category. So for example, if the lawful permanent resident sponsor of a family-based 2A preference spouse or child becomes a U.S. citizen, the petition converts to an immediate relative petition. So if a U.S. citizen would have sponsored a spouse, it would have been an immediate relative petition. But if the permanent resident sponsored that spouse, it's a preference petition. Nevertheless, if that sponsor becomes a U.S. citizen while waiting for the priority date to become current, the petition can be upgraded or converted to immediate relative. Conversely, where the unmarried son or daughter of a U.S. citizen marries, so that's F1, the petition converts to an F3. Petitions that convert retain their original priority date.
I just want to add one thing. It's very important to note that if a child or son or daughter marries before a parent naturalizes, that petition will be revoked. So because only unmarried, only LPRs can sponsor unmarried children. So it's very important for the child not to marry until the parent naturalizes for that conversion.
Next slide, please. Okay, we have our third poll question. In August of 2010, Laura, who is a lawful permanent resident, filed an I-130 for her spouse, Raphael, who is lawfully in the United States on a student visa. In May 2011, Laura became a naturalized U.S. citizen. Can Raphael apply for permanent residence? And here are your choices. Yes, he is now considered an immediate relative. No, he must wait until his priority date is current. yes, but only if Laura files a new I-130, or none of the above. So looking back at the question while you decide and make your choice, we're looking at a situation where a lawful permanent resident is filing an I-130 for her spouse, and that will let us know that this is in a certain preference category, specifically the spouse of lawful permanent resident, which is family-based 2A. So let's see what everyone chose. Hey, 82% of you chose the correct answer. This poll question was about the conversion of the preference petition. Laura was a permanent resident when she filed the I-130 for Raphael. She now became a naturalized citizen, so he is now considered an immediate relative. The petition is converted to immediate relative. Looking at the second choice, no, he must wait until his priority date is current. If conversion did not exist, that would be true, but we know that we are able to create an immediate relative petition out of this. Some of you may have thought that perhaps a new I-130 had to be filed and chose yes, but only if Laura files a new I-130. But the great thing about conversion is you don't have to file a new I-130. Next slide, please.
And now we're going to speak about a law that was passed in 2002, and it was called this Child Status Protection Act, and we call it in immigration circles the CSPA. Adam spoke about the way in which petitions convert. Well, that happens also many times when the children, like let's say in the 2A category, become 21 and they convert to the 2B category. And it also happens when children turn 21, they may age out. For example, their parents are the beneficiary, their father or mother are the beneficiaries of a labor case that's filed on their behalf. And then they turn 21, and sometimes they age out is what they call it. But there are in certain situations under the Child Status Protection Act, in order to account for the delays in immigration processing, in certain circumstances, children remain under 21 for the act, which is called the CSPA age. And in certain situations, the CSPA can be used to help prevent a child's application from aging out when he turns 21 by freezing the child's age or recapturing the time it took for rather than the priority date to become current, for the visa petition to be adjudicated, as well as the priority date to become current. It's a little bit of a complicated formula, and what they do is they look at the date on which the visa becomes available, and they subtract, and the age of the beneficiary on the date that the visa becomes available, and they subtract the amount of time that the visa petition was pending, and that's how they determine the CSPA age. And there are certain children that always will stay a child. An immediate relative child will always remain a child, as well as an asylee child will always remain under 21. It's the derivative children that you have to do that complicated formula and to determine whether they can get the benefit. And also they have to, those derivative children have to apply with their parents or within a year of the visa becoming available. Next slide, please.
In order to sponsor a family member, U.S. citizens and permanent residents can file an I-130 petition. So you file for the relative using Form I-130. Right now, the filing fee is $420. Those filing fees do change from time to time, so it's always important to stay current with what the filing fee is, because if you don't have the correct fee, your application will be returned to you. On the screen, you see a link to the I-130 form on the USCIS.gov website. That is a fillable form, and all immigration forms are available on that website for free. You file the I-130 and relevant evidence at the Chicago lockbox, and you can look at the instructions in the form for slight address changes where concurrently filing with an I-485 or to see the P.O. box of the address. There's also a courier address listed if you want to send that with a courier service. Those filing locations are also changing somewhat frequently, so it's important to check the website to make sure you have the right address. With your I-130, you want to include evidence to establish the family relationship, and what we mean by that are appropriate certificates, such as marriage certificates, birth certificates, etc. Next slide, please.
The next two slides, we're going to talk about some special circumstances under which persons can either regain the old priority date or keep the petition despite the death of the petitioner. Persons automatically assume that where the petitioner dies, the petition dies, and that's not necessarily the case. Prior to recent changes in the law, the petitions do get automatically revoked where the petitioner dies, but there is something called humanitarian reinstatement, and it depends on whether the people are in the United States or not. Under humanitarian reinstatement, what happened prior, if they were in the United States, the I-130 approved petition would be filed with the 485 petition, which is an adjustment of status application, and the adjudicating officer would have the ability to reinstate the petition for humanitarian purposes. And when a person was abroad, that humanitarian reinstatement would occur after the immigrant visa interview. You would come to the immigrant visa interview, and the consular officer would learn that the petitioner passed away, and then they would ask you for evidence to show the reason that they should reinstate for humanitarian reasons. Recently, there was a lawsuit, and it was a very heartwarming lawsuit. What it was a soldier who died in combat, and his wife was here, and they automatically revoked the petition of the wife because the soldier died, and you could imagine the uproar. And there was a very astute attorney who did a class action and sued the Immigration Nationality Service, and they said, no, there's nothing in the law that would say that the petition must be revoked on the death of the petitioner. And what a travesty this would be for a soldier's family who gave his life for the country. So what they did now is there's a bifurcated system. If the petitioner dies but the family is in the United States, USCIS may continue the adjudication for persons residing in the United States. And for persons residing abroad, they would still use the humanitarian reinstatement provisions. And for that, what I ordinarily give a lot of evidence showing that the family's been here a long time, what the hardship would be to give all the birth certificates of the family members that are here. Oftentimes, let's say a parent dies and the other parent is still here and needing medical assistance or whatever, we give that in also. And the other thing is, if you have to use humanitarian reinstatement, you need a substitute sponsor, because when somebody immigrates to the United States, they're required to have an affidavit of support filed on their behalf. And of course, the petitioner must give those kind of affidavit of support, but then they can have substitute sponsor where the petitioner dies, which can be any one of the following family relationships: a parent, a child, a sibling, but even further than that, in-laws, brother-in-laws, sister-in-laws, mother-in-law, father-in-law may step into the shoes of the petitioner that died and give in the affidavit of support. So as you see, it's not an automatic ending of a case when the petitioner dies, not at all anymore. And we can move to the next slide, please. And this is one of my pet love, very innocuous provisions of immigration law that's not known by a lot of people. It's called the Western Hemisphere Priority Date. And what happened is that between 1968 and 1977, some of you may know, that the Cubans were immigrating to the United States in droves. They were running away from the communist Cuba, and what the Immigration Nationality Service did was they put the immigration of other Western Hemisphere countries on hold, and the people registered, and what they got was a non-preference priority date. And in 1977, in the case of Silva versus Bell, somebody from one of the Western Hemisphere countries went to court and sued the government, sued the Attorney General, whose name was Bell, and said, this isn't fair. You know, we want to immigrate too. Why aren't you giving us, you know, our due? We've been waiting all these years to immigrate. They won the lawsuit. And what the lawsuit did was to recapture those priority dates. And it's under the savings clause. So if a person had a parent or step-parents that immigrated any time before January 1st of 1977, their sons and daughters can now pick up that old priority date for any subsequently filed relative or employment-based petitions. And I'm going to give you a little story. 2 years ago, a client, in 2008, a client came to me, and their petition was automatically revoked because the parent had died. It's funny that I'm talking about these two things together, but it was a Western Hemisphere case and a reinstatement case. They came to me, and because they died during the pendency of the petition, it was automatically revoked, and humanitarian reinstatement didn't address what happens if the person died while the petition was pending. In this particular case, the mother was very sick, and she knew that she was going to die, and she wrote to immigration, and she said, please adjudicate my child's son's case. He wants to come to America. I'm going to die. And she even had the letter stating, sorry, we can't expedite any petitions. So they came to see me. And what happened? So I said, well, maybe we can say that the law was illegal and they don't have to automatically revoke under the law. And the other thing that I found out was that my client's mother, who passed away, immigrated to the United States in 1959, and she had a non-preference priority date. And although she was deceased, we were able to get the mother's file and prove that she immigrated, and she had an SA, which is what they called it, A number, and we wound up refiling the petition in 2008, and the step-parent sponsored them, and we got a June 2nd, 1959 priority date. So a lot of times I'll ask clients about, do they have any relatives here? Were their parents ever here? And they always love to say to me, the parents died. I said, that's not the end of the story. It really matters, were the parents here? Did they have an A number? And did they immigrate? Because to their parents, a lot of times they came from the islands and they didn't bring the children. The children stayed back home in the country and wanted to come many years later. And I filed another case where a brother-sister, if you want to go back to that visa bulletin, brother-sister cases take about 12 years. Well, if you filed a brother-sister case today where the parents had immigrated and were deceased, and you can pick up the old priority date, and that person would either be immediately eligible to file for adjustment of status or immediately eligible to come to the United States as soon as the I-130 petition were approved. Next, and I think we finished our presentation.
Thank you, Barbara and Adam, for that wonderful, thorough presentation. Now we're going to go into our question and answer period, where the presenters are going to answer some of the questions that you submitted. I just want to tell everyone that the information that Barbara, Adam, and I give you during this period, please do not construe it as legal advice. We're just giving you general answers based on the webinar today. You should seek an attorney for specific legal advice based on the facts of your case. So, Adam?
Thank you. The first question that I received is, will USCIS notify me when my priority date is current? No, they will not. That's the blunt answer for that one. No, they will not. And I encourage anyone who has a priority date and is waiting for it to become current to be aware of what we talked about with the visa bulletin, with how to determine your priority date, and stay on top of the matter. Follow it along, because if it's going to take years, immigration is not going to sit there with the file waiting to notify everybody, all the hundreds of thousands of people who are waiting. So please take the matter for yourselves, visit the visa bulletin frequently, and follow your own priority date.
And I have a follow-up question with that relates, and maybe we could have a little discussion about this. The follow-up question that I have is, once a priority date is current, how long does an individual have to file for adjustment of status? And with that, I want to walk us back a couple of steps. Because first of all, once a priority date is current, it depends on how long it stays current, as an individual might have to file for adjustment. If it stays current forever and the numbers just keep going ahead and they have a visa priority date prior to that, then there's no time limit in which they have to file for adjustment, unless you're trying to get the benefit of the Child Status Protection Act, in which case derivative beneficiaries who would age out have only a year. But I want to add another thing. Just because a priority date is current does not necessarily mean that you're eligible to file for adjustment of status. And this may be very confusing to a lot of people. But there is something called section, I encourage everybody to read INA section 245I. Now, and also 245A. The people that can file for adjustment of status must either be eligible to file under section 245A or to section 245I. Section 245A says that one person can file for adjustment of status if they either have maintained valid status without violating that status by working. The only exceptions to that rule is if you have been admitted and inspected or paroled. The only exception to that rule, if you've overstayed your time, but you're an immediate relative, that is a person married to a citizen, a child of a citizen, or a parent of a citizen, if you overstayed your time and worked, that's not a bar to someone filing for adjustment. The other persons that can file for adjustment come under section 245I, which has two different provisions. If the priority date of the petition, in other words, if the petition was filed prior to January 14th of 1998, then you can file for adjustment of status once your priority date becomes current. If it was filed before April 30th, 2001, there was a law called 245I, a subsequent extension of that provision that was passed on December 21st, 2000, which says you had to be physically present in the country on December 21st, 2000, and be the beneficiary of a petition filed on or before April 30th, 2001. So there's two parts to that, and one caveat is that if you're a derivative beneficiary, you don't need to meet the physical presence requirements. For example, if your grandfather sponsored your parent, okay, when you were underage, and you were the derivative beneficiary of that case because you were under 21 at the time, you do not need to meet the physical presence requirement. So please, it's very tricky when you're filing for adjustment of status to make sure that you're eligible.
And I would add to that that on when you're doing a family-based petition, when you are in the preference category and you're waiting for a priority date to become current, if you are in a situation where you are able to file for adjustment of status, should it be current? If everything is okay and you can go ahead and file adjustment of status, file it, stay on top of that priority date and file as soon as you can, because these priority dates do retrogress, which is the term used for when they go backwards. Just giving a recent example, in the F2A category, the family-based 2A for considering spouses of lawful permanent residents, I had a case recently where over the summer a lawful permanent resident wanted to sponsor her spouse, and she went ahead and did so because the cutoff date was only a few months prior to her filing. So it looked as though the waiting period to file adjustment of status was going to be fairly short. It was going to be a short duration for that. Well, if you look back at the visa bulletin now, you can see that in May 2011, that cutoff date retrogressed to June 8, 2007. So she was just oh so close to getting the priority date current to being able to file adjustment of status for the spouse, and now it's going to be a much longer wait, and other issues may come into play about filing that adjustment of status. Going to another question that I received. Oh, yes.
Can I actually add something, Adam?
Sure.
Can I add something?
Absolutely.
Adam, that's a great point that you made. So I just wanted to point out we gave everyone the website for the visa bulletin. You should check that website. You should check the visa bulletin every month if you're waiting for your priority date. You can actually, the Department of State, you can sign up and they'll actually email you the visa bulletin. So you don't have to go every month and find it, or you could just bookmark it. But I agree with Adam. As for people like us who've been practicing for so long, the worst thing that can happen is someone's priority date becomes current after years of waiting. They don't have everything together. They can't find the birth certificate. They can't find where their mother is. And then the priority date retrogresses, and then they're no longer eligible to file. So I would agree with Adam to stay on top of checking the priority date. And even though there's no time limit per se, as long as the priority date remains current, I think the best practice is to file as soon as possible, because you do not know what's going to happen the following month. And I want to thank Barbara for that little recap on adjustment of status. For those of you who listened to our adjustment of status webinar, we did go over 245A and 245I. So you can always look back at that if you have questions about what Barbara said. But I just want to reiterate that point that Adam made, because it's really important. So I think, Adam, you wanted to go to your next question?
Yes. I was asked to discuss documentation which can be used to show family relationship. So as I mentioned briefly during the presentation, but I'll expand upon, you can prove family relationship through certificates. That's your primary evidence. So, for example, if you're sponsoring a spouse, you would want a marriage certificate where everybody's name is clear on there. You want to make sure that it's your spouse's name on that certificate. You also want to make sure in that situation that if there were prior marriages, that those marriages were terminated properly before the new marriage took place. Otherwise, that can invalidate the new marriage. So, for example, if a person's divorce decree wasn't issued until a week after they married the second spouse, well, that's not valid for that second spouse.
I just want to say something about that. There's many countries where certificates that may be not issued contemporaneously with the marriage, and they have customary marriages. That's still a marriage, because in the United States recognizes, it's called, the word is comity under law, which means we recognize that countries can have their own laws. And for example, I know in Ghana, they have customary marriages. So customary marriages, you need, even though it may not have been recorded at the time, you need to have a customary marriage and a customary divorce.
So other types of certificates that you can use are also birth certificates, Now, there are distinctions made between some countries issue different types of these birth certificates. They might issue a short form or a long form, and you have to be careful. For example, Canada will issue a short form that does not list parents' names. So you can't obviously use the short form to prove that you are someone's child, since your parents are not listed on the short form. In that case, you have to look to the long form. In addition, even some short forms from certain countries that do have parent names are not considered good enough by immigration and Department of State standards. For example, Poland issues a short form that does list parent names, but according to the Foreign Affairs Manual, which is issued by the Department of State, that short form is not acceptable. Only the long form is. And you can consult the Foreign Affairs Manual. You can look it up on the Department of State's website to find the certificates that are acceptable for a particular country. There may also be poor documentation before a certain date. So, for example, in the listing for Japan, you may find that during World War II, the documents were destroyed, and the Foreign Affairs Manual will give suggestions of other documents that may be acceptable. They might consider affidavits of birth, they might consider school records, they might consider baptismal or similar ceremonial certificates, things like that.
Also medical records, and also immigration where the birth is not contemporaneously recorded. They may ask you for secondary evidence, such as affidavits. Also, what's really important these days is DNA. DNA can prove relationships where the documents may not be primary, and they always give you the right to do the DNA, but you must file the petition first, and immigration has to ask you and send you back the request for secondary evidence. At times, they leave off the request for DNA from the request for secondary evidence, and in those cases, we write back to immigration asking them to include the DNA as a way to prove the relationship.
That's a great point. I just wanted to reiterate what Adam said about the Foreign Affairs Manual. So when you're trying to figure out documentation to prove a relationship, you really need to look at the Foreign Affairs Manual. That's what the Immigration Service and the Department of State uses to see what documentation is acceptable and what needs to be indicated in each document that will be accepted. So if you go to the Department of State website, there will be a reciprocity table, it's called, listed for each country. And on that table for each country, there'll be every document that you can imagine: adoption certificates, birth certificates, marriage certificates, death certificates, etc., etc. And it will tell for each country what's required in the document, and usually says where the individual can obtain the documents as well. So the Foreign Affairs Manuals is definitely key for this question. Okay, so I think we have one more question.
I have one more thing to add to what you said.
Okay.
There are certain countries I've noticed that I think, that they used to be part of England, and where the parents weren't married, they didn't have the father's name on the birth certificate. One of the other things that I've used is when the parents immigrated, if you can get early, like they keep wanting the earliest evidence that you can get as secondary evidence. And at times, let's say the parents immigrated to the United States, and on the I-130 petition, they put the names of their children, and it's 25 years ago. That's going to be very much more persuasive than getting, the latest birth certificate that has a 2011 date. I do have another question that they asked me, Patricia. If you go, all right. So I was asked the question, what happens if a child is not legitimated before 18? When I was speaking about legitimating and ways to legitimate a person, that did not in any way exclude a child born out of wedlock, so that a child can always sponsor a mother, and a mother can always sponsor a child born out of wedlock, even if the child is not legitimated by the father. Now, what happens currently with a father is you have to prove, if the child is born out of wedlock, you must prove that the child had a relationship with their father before the 21st birthday. And that could, you know, I have a client now, 45 years old. There's not evidence 24 years ago, but certainly the father's family's around, the mother is still alive, and we've done it by affidavits, and that's acceptable. And now there's also a case in the Supreme, I think that's going to be going to the Supreme Court, because now we have DNA. So I think they did that when it was harder to prove paternity. And now that we have DNA that could prove paternity, that's possible that that might be overturned and a father might be treated eventually the same way as a mother.
Okay, so I want to thank our presenters for that question and answer period. If we can go to the next slide. I want to tell everyone that the seminar is recorded, and in a couple of days you'll receive an email with instructions on how to access the web seminar. Please wait a couple of days. I know the last webinar it took a little bit longer, and I got a lot of questions about when the seminar will be available. It should be available in about a week. So please just wait a week, and the webinar, we'll send you an email with how to access the webinar. We can go to the next slide. There are some individuals we'd like to acknowledge. They're listed here. We can go to the next slide. And I hope we assisted you today and we gave you some valuable advice about family-based immigration. We tried to answer as many questions as possible. If you have questions that are unanswered about the webinar series or about family-based immigration, feel free to send me an email. My email address is listed there for you. It's Patricia Wonder, my name, @johnsonwonder.com. And I want to thank everyone for joining us today. I want to thank our presenters, Barbara Brandis and Adam Cohen, for such an excellent job. I want to thank everyone for joining us. Please look out for our webinar for next month. It will be on the unauthorized practice of law. We will be talking about how individuals become accredited in front of the BIA to represent immigrants. And we'll also have someone from the government office talking about how different government offices assist people when they're victims of attorneys who engage in unauthorized practice of law. So it should be a really great webinar, and that'll be in June, and please look out for that invitation. So thank you so much. Our webinar is now concluded, and I want to thank everyone again for joining us, and thanks to CUNY. Thank you. Have a good afternoon.
Thank you.